Welcome, welcome, everybody. If you are here and you're in retirement, close to retirement, and you're the kind of where I'm bracketing this is somebody who's got about $1.5 million and some rental properties and some other liquid investments, and you are wondering what's different. What's different about that specific situation when you're planning your estate? I do want to make you kind of the promise of what I'm going to deliver you to today. That kind of an estate, if you lock it down with just a typical estate plan, sort of run of the mill, off the shelf thing, I want to show you really what I think are 3 unique differences for somebody in that situation. You got to protect your rental properties. That's a big part of your estate, and there's unique things to do there. You got to protect those liquid accounts. And honestly, there's things to do to protect your estate from things like lawsuits, creditors, nursing home expenses, all those things that are unique in that scenario. And then how do you balance all of that with making sure it goes to your kids, to your grandkids when you pass as easily as possible? So we're going to blend that all together and show you how to do it to pay as little in taxes, as little in probate or other fees, and make sure your estate has the things that you need. So my goal is really simple. If I can show you the unique pieces of that and help you make sure you understand and evaluate, do I need that unique stuff? Then I think you'll be able to walk out of here at the end of 30 or 45 minutes and say, I know what's different about my plan, and you can just take it and run with it. The lovely legal notices. Yes, so I'm Francisco Servent. I'm the owner and founder of Keystone Law Firm and Lifestyle Planning, where we do estate planning, wealth management, insurance and annuities, and tax strategies. And we do that all under an umbrella service we call Retirement Management Office. This is not legal advice for your specific situation. I need everybody to make sure you understand that. This is general information of an educational nature. I do hope it's helpful, but please don't run out and say, he gave me legal advice. He gave me specific tax advice. He gave me specific. I'm not giving any of you specific advice on anything. Please talk to a qualified professional who can help you get specific answers. And if you need more information, you can check us out at keystonelawfirm.com or retirementmo.com. So, secret number 1, what's one of the big differences here? Like if you're sitting here and you're like, look, I'm living in Chandler. I got my trust drawn up 5-10 years ago. I'm good, right? And the truth is, look, if you've got a house and a little bit of money in the bank, sitting at Schwab or something like that, a typical trust is going to do what you expect. If it's current, if it's funded properly, it's got, the current laws plus your current wishes, it should do what you want it to. But when you've got different kinds of assets, you've got real estate and you've got other liquid investments, that's when you lump things all together into one bucket. That's where problems come up because they're different, very different categories of assets. Real estate carries with it a lot of liability, and that's not the case with investments sitting in a Schwab account or Fidelity, Vanguard, wherever you have your investments, right? You're invested in some portfolio of funds and they grow, they spit off dividends. But if one of those companies gets into a lawsuit, they're not trying to sue you because you own some tiny little piece of the company in your fractional shares, right? It's not going to happen. There's no liability by owning those assets. The liability exists on the real estate, right? Real estate has a lot of liability when you own residential rentals or you own commercial property. Either way, when I first started out, the first lawyer I worked for, I was a clerk in law school, and his job, he'd been doing it for 30 plus years. What he did was he got assigned cases from insurance companies when somebody was sued. And so you can imagine, like if you all have insurance, we have homeowners insurance, car insurance, something happens, some lawyer sends a demand letter saying, hey, blah, 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 blah. We're going to sue you if you don't pay us all this money. Well, when that letter comes to someone, they go, oh, they give it to their insurance company. The insurance company then says, okay, we got to get you a lawyer. He was that lawyer. Okay. And so I got to see a bunch of lawsuits that he had to defend. That's what happens with real estate. Almost all of those cases, real estate was involved. One of them, a gal had tripped over a curb walking outside of a community building where there was some community meeting. She tripped, she really hurt herself, and found a lawyer, and they sued the organization. Well, guess what? The organization owned that property. So there's real estate at risk. Can't tell you how many times I've had clients with rental properties who something happened, somebody got injured. There was something that was, one case was horrible. They owned a small apartment building that had a community pool, and somebody drowned in the pool. They're going to sue whoever owns that real estate. And if they win, they're going to get the real estate. So that's why real estate, when you own it, even if you have one rental, it's just a unique, different kind of asset, and you don't want to blend it in with everything else. So the first part of an estate plan, when you own these two categories of assets, is to separate your assets. Separate out the assets that have high liability, because it's not just an asset. It's not just money in the bank. It's an asset, but it also has risk. And so you want to insulate that risk away from your other assets. So what we call that is, let me just kind of give you a little picture. You want to think as, you've got your regular home, you've got your money in the bank, etc. What you want to do is you want to pull out your rental properties and put them into something else. Okay. And so you take them and you plop them into a completely separated thing to separate the liability of them. You're not separating out the fact that you own it or the fact that it's yours or the fact that you get the rental income, but you're separating out the liability. So the main way we do that is we clear that screen, is we build a firewall. That's just a simple way to think about it. So you're going to have the standard thing that you need, which is that trust. And that's going to hold your liquid investments, brokerage accounts, your bank account, your primary home. All of that's going to go into that. And that's what's going to keep it organized, so there's no conservatorship when you become incapacitated, and there's no probate when you die. That's the organizing piece of your whole estate. What we have on the side, though, is that LLC. So that's what protects your rental properties and the liability from those rental properties getting to the rest of it. So how does that work? So first thing you need to know is that that's a really ugly drawing. First thing you know is that a revocable living trust does not protect you from creditors. So whatever you put in there, if you end up getting sued because you're in a car accident or you're in some profession that has a liability, they're going to be able to get in there too. That's just the reality with a revocable living trust. There's no creditor protection. There's no asset protection. While you're alive, your money, your property, your stuff that's in your trust is subject to all of your liabilities. So if something happens and you get a judgment against you, they're coming in to get what they need. You might have insurance, hopefully you do, but they'll be able to get in there and make sure they can satisfy the full judgment out of your insurance and the rest of your assets. That's the first thing to know. When we're looking at rental properties and you decide to put them into an LLC, we'll draw a little funny little castle. If you have a liability over here on your personal side, what's interesting is Arizona law doesn't let them get into your LLC. Obviously, it has to be set up correctly, has to be managed correctly, operate correctly. You have to follow all the rules, and they are absolutely required. Otherwise, they can get in there. And if you don't follow the rules, when that liability happens, they're going to get in there despite that you have an LLC. So it has to be done correctly. But if they can't get in there and they try, it just bounces off. They try, it bounces off. You'll be able to protect those rental properties from being forced into sale to satisfy that judgment. The other side of this is what I've been describing here. Let me draw my little castle around that rental property better. Okay. The other thing that happens is if you have a liability on the rental property, somebody trips and falls, somebody, who knows what, right? If you have a pool, something bad happens. If there's a liability in there and they sue and they win, and it's more than your insurance, that liability can't get out. It stays in here. It's blocked by the wall of the LLC. They may get that one rental property. Okay, that's very likely, but they can't get out to your other stuff. So your primary home, your investment accounts, your money in the bank, your whatever else you have. Okay, they can't get to it because that creates that firewall. And if they can't satisfy the entire judgment out of that rental property and your insurance, then the judgment goes away. They just don't get the rest of the money. So now what if you have multiple properties? Multiple properties, the best thing to do there is to create, multiple little castles. You create one LLC for each. That one's a little wonky. But you create an LLC for each. And then what you have is now you have the liability of each rental separated from the liabilities of the other. They can't get to each other either, right? There's that firewall between each. And then if you really want to get sophisticated, for our clients who have, usually it's 5 or more pieces of real estate, is they'll set up a master entity that acts as the property manager for all of your rentals. And then the entity that is owning the real estate is not the entity that is managing the real estate. So if somebody says, oh, we slipped and fell, we had something bad happen on the property, they really have to sue the manager because the manager is the one that's liable. The house was just sitting there. It was just a house. But the property manager is the one that actively took the responsibility to manage those properties. And so if they didn't maintain the properties well, if they, if the fence around the pool was damaged or destroyed, or the gate didn't have a lock or a working lock, or all these things, right? They can sue the property management company. But again, then the liability can't get out of this entity and it can't get down to your LLCs because you've put a firewall between them. All these layers are essentially what you're looking to do when you're thinking about asset protection. Then what you do is you have each of these entities, all of them, in some way, you own them all. But yes, you can make them all owned by your trust. And that ownership of your trust, does not eliminate that firewall. It keeps it in place, actually. And so you own everything, you get all the rental income, You enjoy the fact that you have these properties that are growing in value, that are spitting off rental income to you, etc. You can be your own property management company. So all this is still you, but you're putting layers upon layers upon layers between everything. So we've got layers between each entity. We've got layers between the management of the rentals and the ownership of the rentals. And then even the management entity is layered off from the rest of your life. So all these layers, so like I said, you have to set them up correctly, manage them and operate them correctly over the long term. And if you do all of that, you get this protection. Here's what else it does. Somebody sues you, and maybe the lawsuit has to do with something in your property management, one of the rentals, or you individually, whatever it is, it doesn't matter. Somebody sues you for any of those things. You've now created this web of layers and confusion that any lawyer out there, he's going to look at this and go, oh boy, this is going to be hard to figure out. Honestly, because I've had to try to do that. And the lawyer's going to tell their client, okay, they got all these layers and entities and master entities and blah, blah, blah. Like this might be hard to collect, even if we win. That is a big reason to do this. It creates a disincentive for those plaintiffs' lawyers out there to even take the case. Or they take the case and they get into it and they're like, oh, this is going to be a pain. For real. And the more you can make it look like a pain legally, the better defense you have of ever having to deal with this thing. And it also helps with your insurance because guess what? If they see this, the plaintiff's lawyer sees all these layers and your insurance company is like, look, we're only going to offer a small amount to settle this thing. That plaintiff's lawyer is more likely to accept it because that's money in the hand. Trying to go collect against all this stuff and break through and pierce the corporate veil and show all this, that's a lot of work. They'd rather just take the check and tell their client to take the check. So the layers, the visibility of all this stuff is a deterrent to big lawsuits coming after you. All right. So that's our first main thing that I want to cover. The second main thing is what happens when you set up a trust and you put your stuff in it, and maybe you've got, you got your rental properties and LLCs, you've got things layered correctly, but ultimately all of that is owned as the top thing is your trust. It's the top thing that owns everything. What happens as you get older? And one of the horrible things happen. You need nursing home. Right? You need nursing home expenses. Arizona, the averages are they go up every year, but they're in that kind of $8,000 to $10,000 a month range. For good nursing home costs. Sometimes you can get it cheaper. We all know what cheaper means, but now you're thinking about shelling out $8,000 a month, $100,000 a year. And if you're married, you're looking at your spouse saying, there's two of us, right? What if you get sued? We talked about that. And you can use all those strategies I talked about before about separating your rental properties into different LLCs and using a management company. Well, what if all this stuff that's in your regular trust is still at risk? Now, the first layer, number one, is an umbrella insurance policy. That's the first layer because guess what? If it's covered, they're going to pay for your lawyer. They're going to pay to settle it. They're going to kind of deal with all that cash that goes out the door. And they're relatively inexpensive. Second layer is you look at setting up those LLCs that I talked about just a minute ago. The third layer is what we're going to talk about here. It's some type of an irrevocable asset protection trust. All right. Irrevocable asset protection trust are complicated. They are a whole semester-long course in law school. It's a giant category of information to learn about it because there's so many different types. They are all customized, or they should be, and they do different things. They have different consequences for tax purposes. gift, estate, and income taxes, they have different consequences for how much you can actually access the money, right? Some irrevocable trusts, you have full access. Some irrevocable trusts at the other end, you have no access. Once you put it in there, you can't touch it. It's a whole spectrum of options that you have to balance for what you're trying to do. So the way they work in Arizona on that spectrum, if you have no access when you set it up, that's the side of the equation in Arizona that gives you more protection. Okay. That's more protection. The less access you have. The more access you have less protection. Okay. And that's just how the law kind of generally goes. So there are trusts you can use, irrevocable trusts you can use to put your assets into them, and following all the requirements, all the criteria, all the fine print of the law, those assets are protected from ever being taken in a nursing home expense. They can't be used. And what that does is it helps you get qualified for benefits that are out there. They can help pay for that. So protecting, and there's no limit on the dollar amount you can put in those irrevocable trusts. None. On another version of this, if you want to make sure your own trust assets, the stuff you don't put in LLCs, not the rental properties and that stuff, but everything else you put in your trust, if you want that to be protected from creditors, if you got sued, you can use an irrevocable trust. Arizona allows something that's a little bit of a hybrid situation where instead of giving all the way no access and getting full protection, there's something that sort of falls, I don't know, a little bit to the right of the middle, where you have a hybrid asset protection trust. You put it in there, you have some access, you have some control, but not all. Okay, so it can still be used for lifestyle, for your expenses and things like that, but you are giving up the control of who writes the check. It's not you anymore. So it's somebody you trust, who's going to help pay your bills, things like that. But you can establish a hybrid asset protection trust in Arizona to actually protect your brokerage account, your cash in the bank, the equity of your home above the homestead limit. There's a whole bunch of things that are in your regular trust, which is where they should be, that could be protected using an asset protection trust. So there's a lot that goes into that, questions and pros and cons and things like that. But plant the seed so you know it exists. And we talked about that. And that's just a little bit more about how the asset protection trusts work. It's where you lock things away. It's irrevocable, though. And that's why it takes some consideration and thought before you just plop $1 million into it. They can be set up to avoid the estate and gift tax, which is great. And it even can be set up to avoid that for multiple generations. If you've seen Benjamin Franklin, he set up a trust that was not to be, it wasn't allowed to be, no withdrawals were allowed. I think it was for 100 years. Yeah, for 100 years. Put money in there. And he said it's to benefit these two cities in Pennsylvania. And he said, but can't be touched for 100 years. And so the trust basically just invested and reinvested and reinvested and reinvested, and it grew. I think his contribution was pretty modest. I don't know what it was, but by the time it was ready for distribution, there's millions of dollars in this trust. Cool, right? And you can kind of do the same thing, leaving it to your kids, for your grandkids, for the great grandkids, et cetera. You can say, hey, I want this to kind of stay and grow and benefit everybody. If you don't do it correctly, you got estate tax at every generation. Well, this kind of trust can avoid the estate tax completely. And it can be set up to where your home, your assets, your personal things are not going to disqualify you for benefits for nursing home. All right. Well, if you do all of that, how do you still make sure it goes down the generations? And then you make sure it goes down to them in a way that, if they get sued, if they go through a divorce, right? one of the first wills I ever drafted was a really nice family in Chandler. And it was just the mom had passed years ago, had 5 adult kids who were in their 50s and 60s. And it was basically just to the kids equally. And, it was a young attorney. It was a very simple estate. I think maybe he owned a home with a couple 100,000 equity. And yeah, I think he had about 200 or 300,000 in all of his, life savings. And it wasn't long till he passed away. Then a couple of the kids came back. They passed away. We need to execute the will. And we did. And it takes time to do that. You got to go to court, get it approved and filed and probate and all this stuff. We're going through the process. And as we're going through the process, before any money gets distributed, this was around 2008 or 2009. A couple of the kids, it was actually 2 of them. One lost their job. The other was already in kind of financial trouble. They both filed bankruptcy. And what happens in bankruptcy is bankruptcy ends up finding out if you are an heir to anything. They found out. And so actually what happened is the 2 kids who were in bankruptcy, their full share went to the bankruptcy court to be distributed among their creditors from dad's money, not from their money, but from dad's money. Contrast that with years later, many years later, I'm working with a gal who was planning her estate, and I had learned this strategy by then. And she said one of her kids was kind of a recovering addict, in and out of rehab a little bit, has had a good run. She had 3, but one of them she was worried about. So I suggested this strategy. She said, let's do it. And she passed less than a year later. When I was working with her, sort of knew that was coming. Her brother was the trustee working through administering things, and something similar happened. The one who was kind of the one that was struggling ended up in bankruptcy before any distributions were made to anybody. Totally different result. The bankruptcy court found out. The bankruptcy trustee's office contacts me directly because I'm the attorney for the trust. Says, hey, this one's in bankruptcy. We need all this information, and you're going to end up having to send us all the money, blah, blah, blah. Knowing what I did for the client, I sent back a nice letter saying, no, we're not, because of A, B, C, D. She had set his share up in this kind of a trust, which under Arizona law, under bankruptcy law, is completely exempt from you being able to touch it. And took a little bit of time, maybe 30 days, got a response back, and was like, you're right. Thanks for letting me know. See you later. His money stayed in trust. The uncle manages it. The uncle gives him money as he needs it. It's still there. He hasn't lost it. And that's the key difference with this strategy. We call it a beneficiary protection trust, where you give it to them. It's like if you're leaving an inheritance to your kids, like you're leaving it to them. This just leaves it to them in a separate bank account so that they can't lose it on accident. I mean, how many adult people go through divorces? If they take that inheritance and, they start doing nice stuff for their family and years go by and then they get divorced, you can guarantee that the in-law, they're going to get a lawyer that's going to say that's all community property, and what you left your kid is now being split with their soon-to-be ex. But when you put it in this kind of a trust, that can't happen. They get it in a separate bank account, has to stay there. It can be invested and grown in a separate investment account, but it can't be lost if any of that stuff happens. So this gives you huge benefits of protection, not for you, but for the next generation. And that can just continue. If they don't spend the money, it just sort of goes right down into trust for the grandkids, or you can say where it goes, but it just keeps going. And that protection stays with them until the money's gone. Divorce, it does divorce protection, like I said, creditor lawsuit, you can turn that into an education vault for the grandkids, where it's like, oh, I got little grandkids. I want to sock some money away and let it grow until they start going to college. And then great, it can do that. The other thing that's really cool about this is what you put into these kinds of beneficiary protection trusts, they get the step up in basis when you pass. And that can wipe out a ton of capital gains. A lot of clients, they're like, I'm ready to sell the rental. I don't want to sell it, but I have huge capital gains. And if I do, it's like, look, you're 85 years old. And if you can manage to hold on to it, sometimes it's a very simple thing. Or stocks. I mean, stocks, a lot of times clients bought, Pepsi or whatever 20 years ago, 30 years ago, and it's grown like crazy. And there's so much capital gains. There are other ways to help reduce the capital gains tax bill than just waiting to leave it as an inheritance. But if you're going to keep it anyway, if you're not really sure, or if you're quite elderly, you might consider just letting the step up in basis that happens when you pass be the thing that gives them this huge tax benefit. One of my early examples was a gal who came in. Her mom had passed. It was her and her sister, and she said that her mom just passed recently. Her mom had quit claimed her and her sister the house before she died to make things as easy as possible for them. She brought in the mom's will and said, she was like, what do I need to do? We're going to sell the house. And I had to tell her, because your mom gifted this to you during her life, what that meant is you don't get the step up in basis when she passed. So she had bought that house, I think, for about $100,000. When they were getting ready to sell it, is worth about $400,000. So there's $300,000 of capital gains at 20%. It's a $60,000 tax bill. We were able to find a strategy that was approved by the court and the IRS, but it was a giant project and a nightmare. It cost less than $60,000, so it saved them. But it's a whole lot easier to just do it the right way the first time. Use that step up in basis. So I kind of got through material a little quicker, 30 minutes. So these are the big differences, right? You line up what the old traditional kind of planning is, a simple will or something cheap online, just kind of a simple trust. It leaves your rental properties exposed to your liabilities, leaves your liquid investments and everything else subject to all your creditors. And the difference, right? What I'm showing you today is that these are major differences. You want to set up a split between those assets. Figure out if you want some asset protection or some benefits planning, and then look at how you can keep things protected to stay in your bloodline if that's what you want. Now, questions. I'll take questions by chat. I'll take questions by, let's see, I think I can give you guys microphone authority. Yeah, sure. And thanks for posting that, Alexis. So we always got upcoming more topics, more webinars. So, and you can see them on our website, keystonelawfirm.com/events. They're listed there. You can register right there. The next one coming up next week is by Michelle Dexter, my partner, Generational Walls, Structuring an LLC for Privacy and Seamless Succession. So check that one out. If you have rentals, if you have things in an LLC, check this one out. It's great. Michelle and I have been working on the outline for that one. And then on August 19th at noon, I am going to be doing intro to wills and trusts. If you know somebody who's looking around, they know they need to update, they should do something, send them to our website. And that's a great one to jump on. I go over the basics. I go over our process. I talk about our fees. So jump on that one. And then you can always find the recordings on our YouTube channel, youtube.com/keystone. But if this topic kind of hit a chord for you, then give me a call. Let's schedule time to talk. You can do a discovery call for free with our intake team. Alexis manages that, and he'll say what's going on. What do you have? And he'll tell you if he thinks we can help. If you want to sit down with either myself or Michelle and have a full hour to really dig in and really map out what the exact strategy would be, what would that blueprint look like for your estate plan, we do those as a paid consult, and my office can help you get that scheduled. I don't see any questions coming in. So,
Francisco, I have one if I can.
Yeah, please.
So one of the things that I see with some of our clients is that they may be upgrading or downgrading their home, and they want to turn their present home into a rental. Their present home has a mortgage on it, and so they're wondering what the policy is with regards to their mortgage with transferring that property to an LLC. Do you have any words of wisdom for them on that?
Yeah. So one of the considerations there, just before we get to the mortgage question, is that your primary home has a really good capital gains exclusion in the tax code. So you don't pay capital gains on your primary if you've got less than $500,000 for married couples. I think it's $250,000 for single persons, but you have to have lived there for 2 of the last 5 years. So just watch out for that. You can turn it into a rental. As long as you sell it within 5 years, you get that some capital gains tax avoided. If you have a mortgage on it and you want it to become a rental and you want to put it in an LLC, then you do exactly all of that. So, among the attorneys that are in some of our local Arizona estate planning associations, we talk about this, and the experience and the best practice is to put it in the LLC, change the title, knowing that all mortgages in Arizona have a clause that says if you transfer the home to anybody, we're going to call the whole balance due. And putting it into an LLC meets that clause. Like, it could trigger that clause, but the mortgage company has to initiate triggering that clause. And so you got to know that that's a right they have in the mortgage contract. But among everybody that we talk to about this, it either none of us have ever seen it happen, or it's so infrequent that I don't even remember one lawyer saying they've ever seen a bank do that. And the reason is, if they're getting that mortgage payment every month, they're not going out and checking what's happening. And so you get the protection of it. And so that's generally what we recommend. Obviously, it can be different just depending on what your situation is. We do have a question in the chat. If I have collected rents with Zelle to my personal account, can I still be sued if the property is owned by my LLC? Yeah, because what that shows is that you personally are managing the property, right? And so if you personally did something negligently in your management, then you personally are going to get sued. So that's one of those things you want to separate out, right? Have it owned by an LLC, have the rent come to a bank account in the name of either that LLC or your property management LLC. And then you've separated these things from each other. One more question in the chat. Protection trust, separate for each category, such as protection from healthcare, charge cards, debts, or the IRS, or one for all possible creditors. So good question, Louise. The beneficiary protection trust, on that side of it, what you're giving to your heirs, that's one trust can protect from all the things. For yourself, if you want to have protection for different things like that, it might be different trusts. It might be one trust that's sort of a blend of different things, but it's going to come down to very specific analysis of what kinds of assets you have, what kinds of bank accounts you have, what kinds of investment accounts you have. All those things are going to come into play about what type of trust might work for asset protection for you. If you change that today, so back to the question about the LLC rent, if you change that today, like you started having the rental income not go to your personal account, but to an LLC account, and something happens in 5 years, can I still be sued? Well, yes, all of us can be sued, but the idea is we want to get it shut down as soon as possible. And I would say that changing it today is the thing to do. Like, that's the standard recommendation. Get that rent, deposit it into a bank account in the name of the LLC, because then it shows the LLC is separate from you personally. So I would definitely make those changes. And Michelle, did you have another thought, another question?
I was just saying that you want to remember that your LLC should have a separate tax ID number. And if you're going to open up that bank account in the name of your LLC, they will require that separate bank account number. That's part of, distinguishing the difference between you personally and your LLC as a separate entity. And so when, you're talking about changing that today and updating that, just keep in mind, if you have not already obtained that EIN number or tax identification number, you're going to get to the bank and they're going to turn you away because you don't have that.
Yeah. They'll look at you with cross eyes and they'll go, you need an EIN. And you'll say, what? So just make sure you get that tax ID number before you go to the bank, because the bank will require it. And then I'll grab the link for anybody who wants to schedule a free discovery call to talk about this or other stuff. It's in the chat. And let me finish putting it in there. Just a second. And you just click on that, find a time on the calendar, no cost, and talk to Alexis and figure out what's going on and if it's something you need to move forward on. If you want to do a full hour consult with me or Michelle, you can again find those online. The time on that calendar I just posted, you pay for it right there, and you'll get an hour, and we'll blueprint whatever we can in that hour for you. With that, I'm going to wrap us up. Everybody, thank you for coming. We'll see you at the next one.